Welcome everybody. Thank you for joining us for another session of ALMA's book launch series. My name is Idor. I'm the chairman of ALMA, Association for the Promotion of International Humanitarian Law, an independent non-profit NGO, which aim is to promote the knowledge, understanding, and discussion of IHL. And in that line of thought, we have established this very, very interesting series of book launch events. And we're very proud to have in this event double book launch event. That's very interesting, that's very special, very unique under the concept of detentions and confinement in our conflict. We're going to have two discussions, or we're actually going to have a moderated discussion on this topic. And for that, we're going to have, and I'm going to thank in advance to Yelena, Ezequiel, and Tilman for their participation. And I'm going to give the floor to the series coordinator, Natali Admon from ALMA, to introduce the speakers.
So, hello everyone. I am very excited. This is my first book launch event. So my name is Natali. I am the book launch events coordinator of ALMA and the newsletter editor. By the way, we've just published our latest newsletter. So if you haven't got a chance to see it, I am adding the link right away. So I would like to introduce you to our speakers. So first, Dr. Ezequiel Heffes is a senior policy and legal advisor at Geneva Call, a humanitarian NGO that promotes respect of humanitarian norms by armed actors. Ezequiel holds a PhD from the University of Leiden, an LLM in IHL and human rights from the Geneva Academy, and a law degree from the University of Buenos Aires School of Law. Prior to joining Geneva Call, he worked as a field and protection delegate and as the head of office for the ICRC in Colombia, Afghanistan, and the Democratic Republic of Congo. He has participated in different research projects and has published various articles and book chapters on different international law issues. He is the author of Detention by Non-State Armed Groups Under International Law, and is the co-editor of International Humanitarian Law and Non-State Actors, Debates Law and Practice. He is also the co-editor of the Armed Groups and International Law blog. Thank you for joining us today. Our second speaker is Dr. Yelena Plamenak. Jelena is an international humanitarian lawyer with over 15 years experience in practicing humanitarian and human rights law in international criminal justice systems and humanitarian organizations. Since 2017, Jelena has served as an international humanitarian law expert, mandated to provide legal advice to key humanitarian and diplomatic actors responding to armed conflicts in the Middle East and North Africa region, to enhance the protection of civilians in armed conflicts. These situations included Syria, Yemen, Iraq, and Libya. Prior to her regional mandate, she served for almost 10 years at the offices of the prosecutor of the International Criminal Court and the UN International Criminal Tribunal for the former Yugoslavia in The Hague. There she was responsible for legal analysis of serious violations of international humanitarian law and human rights law in situations under the prosecutor's preliminary examination. During her time at the ICC, she was a member of the working groups on the prosecutor's policy on sexual and gender-based crimes and policy on children. Jelena holds a PhD degree in law from the Faculty of Law and of the University of Geneva. Her recent book, Unravelling, Unlawful Confinements in Contemporary Armed Conflicts, based on her doctoral thesis, has won the prestigious 2022 Francis Labor Prize awarded by the American Society of International Law for an exceptional book in the field of the law of armed conflicts. And now I would like to introduce you the moderator of this event, Dr. Tillman Roddenhauser. For the past 6 years, Tillman has been a legal advisor at the International Committee of the Red Cross headquarters in Geneva, Switzerland. In that position, he has provided legal and policy advice on a number of IHL issues, including detention by non-state armed groups and detainee transfers. Between 2016 to 2018, Tilman led a diplomatic initiative by the ICRC to strengthen IHL, protecting detainees in non-international armed conflicts. Tilman holds a PhD from the Graduate Institute of International and Diplomat Studies in Geneva, which he published as a monograph entitled Organizing Rebellion, Non-State Armed Groups Under International Humanitarian Law, Human Rights Law, and International Criminal Law. He has also published various articles in renowned international journals and received different awards for his work, most recently the 2022 Francis Leber Prize for an article on partnering in detention and detainee transfer operations. Tilman, the stage is yours. Thank you so much all for being here today.
Well, thank you very much, Natali, and thank you, Ido, for having organized this double book launch. I must say that I'm extremely honored. It's a great pleasure, and it's an honor to moderate the launch of Yelena Plamenac's book on Unravelling Unlawful Confinement in Contemporary Armed Conflict, and Ezequiel Heffes' work on detention by non-state armed groups under international law. It is great to be here in this framework and to be with our audience to discuss both of these books. I must say I have been looking forward to that event for some time because I enjoyed reading both books a lot. So I want to start by congratulating both of you, Jelena and Ezequiel, for having completed the doctorate in international law, and more importantly, in my view, by having published your work in such important international law series. You have my full admiration for that. And I must say, I must admit that I had, even before they were published, I had a chance to look at your work. And I was thrilled to see them coming out, to see your work coming out as books. And that's mostly for two reasons. The first is that your books tackle a humanitarian challenge, and they do it through a legal lens. And when one reads your introductions to the books, one can see that you really want to start from a reality that is out there. And the reality is that as we speak, there are thousands, probably hundreds of thousands of people held in relation to non-international armed conflicts. They find themselves often in the hands of the enemy. And too often they are ill-treated, they're held in substandard conditions. And I would argue they're held arbitrarily. And your respective books tackle these issues by looking in particular at the procedural safeguards that are there to prevent unlawful confinement or arbitrary detention, as you both term it. And the second reason why I'm so excited about your books now being published and us launching them is that your books are based on practice, on the actual practice by parties to armed conflicts. And we will come to that in our discussions. But what I find compelling by your books being grounded in practice is that you take the long-standing discussions that we have among international humanitarian lawyers on these detention issues, you take them out of the academic sphere, or the primarily academic sphere, into a sphere of application, of applying the law to today's reality. And in this respect, I think both of your books make a great contribution to scholarship, but also to international practice. So I don't want to speak much on myself, but I want to get us started. However, I would like to say one term or one point on substance just to frame the discussion. And that is the following. So when we look at detention in non-international armed conflict, we can find some of the most intriguing and challenging legal issues here. And we will get to some of these issues today. But what I think is important when we discuss these areas that are gray or these areas that are unclear and that pose real legal challenges is that we don't forget that there are many rules that protect detainees that exist, and they're very clear. And what I mean by that is there is an imperative to treat detainees humanely and without any adverse distinction. There is a protection of life and dignity of detainees. So no one must be ill-treated, must be tortured. Sexual violence is prohibited. These rules are very clear. And so is also the requirement to provide humane living conditions for detainees. And so I emphasize that because we get today into very interesting points and challenging points on procedures and how to avoid arbitrary detention, unlawful confinement, procedural requirements which are legally sophisticated. And when we do that, I don't want us to forget that there are other rules that we may not discuss, but which are practically extremely important. So for our lunch today, I have a few short questions that I would like to ask Jelena and Ezequiel, but then I would also need you, the audience, to pose your questions. And you can do that while we speak, while we discuss, and I will take them from the chat and pose them to Jelena and Ezequiel. But we'll also be careful that we don't, that I don't ask too many questions, but that I will leave sufficient time for everyone else to come in with questions. So, but now over to you, Jelena and Ezequiel. And I want to start with a question not on the legal substance primarily, but more on the process of writing your impressive books. And here, what I find remarkable is that both of you wrote your PhDs, which are the basis of your books, not right after graduation, as most people do, but you did it after you had worked in the humanitarian and legal fields for a number of years. And from my own experience, I know how hard it is to work and to write a book at the same time. And it's very time consuming, it's very heavy. So I wanted to ask first, what motivated you to write a book, to write a PhD, and also what made you look at these particular angles of detention that you chose to examine? Maybe ladies first to Jelena.
Hi, Tilman. Thank you so much for that wonderful introduction. I'm equally honored that you are moderating this talk today. Thank you, Ido, again, now officially for hosting this event. And hi, Ezequiel. It's lovely to see you virtually here too. I look forward to chatting now in front of the public about our favorite subject. So let us kick off this talk with explaining what motivated me to write this book. As you rightly pointed out, certainly the fact that I wrote it after practicing the law for a while was the first paving a road to this book. I found motivation in practice. I wish I can tell you a nice romantic story that inspired me to go out there and, as a curious researcher, find some answers and solutions. But in fact, what motivated me was an inner feeling of frustration and injustice for people affected by non-international armed conflicts, who are simply excluded from a strong or robust legal framework that protects them from unlawful detention. And the first time I felt that way was when I was doing my internship at the Tribunal for Former Yugoslavia. One of my tasks was to write a legal memo on transfer standards that would apply to detainees captured in non-international armed conflicts. And I realized that there is not much that prosecutors could use to find the accountability for unlawful behavior of some of the commanders involved in detainee transfer. And these detainees were afterwards executed in cold blood. And I first tried to tackle the subject by proposing my research through a theoretical lens of looking into the relationship between international humanitarian law and human rights law. But I soon realized that that was unrealistic and it would not be useful for prosecutors. So I moved on with my career. I went to International Criminal Court, also for the Office of the Prosecutor. And there I multiplied my feeling of injustice because I didn't see it only in one context of former Yugoslavia, but now I could face it based basically in every context of armed conflict that was on my table, and those were like most of the conflicts around the world at the time. It took me 7 years to contemplate the methodological angle from where I really wanted to go in the field, examine exactly what is going on the ground, how both states and armed groups detain when it comes to those three unregulated aspects of detention in NIACs: grounds, procedures, and transfers. And then to go back and try to make sense of that data and offer it to practitioners, as I used to be, and help them to either prevent or punish unlawful detention by both states and armed groups. So that was my motivation. And obviously, it was a long road of selecting the case studies and going into that methodological substance. But I can go into it afterwards. I would like to maybe stop here and also give the floor to Ezequiel.
Thanks. That might not have been a romantic story, but I think it is a compelling one. And one thing that I often observe is I often have the impression that very good articles and very good books like yours, they stem from realizing that there is an issue in practice that needs analysis. And such analysis then often turns out to be as impressive, and I truly believe that, as your book is. So over to you, Ezequiel.
Thank you very much. Thanks, Tilman, for the nice words. Thanks, Ido and Natali, for organizing this. And of course, thanks to Jelena. We have had some discussions before the books came out about this when we were reflecting on the topic. So it is indeed great that we can see each other today and further exchange on this. So the motivation, I would say the motivation to write specifically about this topic came probably, I think it was in 2014. So I had already an interest on non-state actors and non-state armed groups before 2014. But what happened in 2014 was I was working in the field and I was interacting with some groups, and I was also interacting with possible detainees, with individuals who had been detained, and the Sardar Mohammed decision came up. And what Sardar Mohammed, what the UK court said, Justice Legat said in 2014, was that IHL would not provide a legal basis for states to deprive individuals of their liberty in armed conflict, in non-international conflict. And I was in the field, and for me it was, that triggered my mind in terms of what would I respond if a non-state armed group would ask me whether they could lawfully detain an individual or not. What would I respond if a detained individual would ask me as a humanitarian worker whether that detention is lawful or is not lawful? And so the combination between that specific experience on the ground and seeing what it was being discussed at a domestic level in the UK kind of triggered my reflection and thinking, okay, I mean, at the time I thought, and I was convinced that international humanitarian law would be actually the legal basis for specifically for internment. So it's like if an armed group would detain, for instance, a member of the enemy forces for security reasons, then in my mind, I had just graduated from the Geneva Academy. So in my mind, it was clear that it was international humanitarian law. And my reaction at the time was, if I had been asked by a non-state armed group about this, I would probably have responded this. And then in parallel, what happened in 2014, 2015, it was also that there were developments at the ICRC with respect to their position, the ICRC position with regards to detention. So there was also that discussion that came out at the Red Cross and Red Crescent conference in 2015, and also so it was kind of this combination between the practice of armed groups around the world. They were and they are proactively detaining individuals for different reasons. The Sardar Mohammed, my interest on non-state armed groups and non-state actors in general, how international law conceives these entities that are not states, what actually they can do or they cannot do under international law, and the ICRC work on this. I think the combination of all those different views and positions was that actually triggered the motivation to write specifically on this. But I would say that my book is not, of course, the focus of the book is on detention, and the case studies analyze how armed groups deprive individuals of their liberty. But I would say that it deals mostly or more broadly with non-state actors and non-state armed groups and their position within international law. So I would say that detention is the case study of, how an entity that is not a state and doesn't have the prerogatives of the state under international law and potentially under domestic law is dealt with. I would say that that's kind of the focus and how those different issues interact.
And you have indeed chosen not only one complicated issue, the role of non-state actors in international law, how they're regulated, how they interact with that system, but then the case study of detention, which is particularly interesting and I would say challenging. But before I ask you precisely about the content of your book, I have one other question. When we look at your books, what I find really remarkable is that both of you actually included case studies. Jelena, you on Afghanistan, on Syria, and on Ukraine. And Ezequiel, you on groups in Colombia, in the Democratic Republic of the Congo, and in Syria. And this is not common for international law monographs. You often find case studies based on UN documents or based on jurisprudence. But you actually went and spoke to some of the actors that you are writing about. So could you elaborate a bit on, one, why did you choose to bring in these case studies? But then also, I'm extremely curious, but I think people might be too. How did you manage practically? How did you manage to speak as researchers to members of parties of active armed conflicts? Thank you. Maybe this time we start with Ezequiel and then we move to Jelena.
Thank you, Tilman. This is a great question. I should have said that I'm speaking in my personal capacity. This is a statement that sometimes I forget to mention at the very beginning, but I am speaking in my personal.
It's your personal.
It is a book, I know. But since I work for a humanitarian organization that interacts with non-state armed actors in the field, so I should clarify this from the beginning. I think it is including case studies is essential. I would say for two main reasons. The first one is analyzing how the law is applied cannot neglect the views of those that are in charge of applying the law. So this is necessarily, when we speak about international humanitarian law, this involves assessing how non-state actors and state actors also, but for my book, it was specifically non-state armed groups, they deal with the law and whether they apply the law, whether they don't apply the law, whether they know the law or they are not aware of their obligations under international law. So I think that was kind of essential. This is one of the reasons. The second reason is that I believe that for a number of years, there was a disconnection between legal studies and other social sciences studies. So in the past 20, 30 years, there have been a lot of studies and scholarly production on non-state armed groups, not so much from a legal perspective, but from political sciences, sociology, anthropology. And I think it is, for legal discussions, it is quite important to bring those perspectives because they may serve to, for instance, to actually understand why certain behaviors take place in the conflict, to develop what the ICRC called a set of expectations, how we can actually predict that parties to the conflict will behave. This is not just such a legal analysis. It might necessarily involve other social sciences. So the case studies, they are reflective of these 2 points. The first one, that the legal analysis should actually include the practice of those involved in the application of the law, but also how other social sciences may help to understand the application of the law on the ground. Great.
And I might insist after Jelena spoke on the part of how do you get in touch with these actors, especially on the non-state armed group side. But first to Jelena.
Thanks. So why the 3 case studies? I do explain quite extensively in my book why EM. But what they have in common is, first, they are very rich and potent case studies that provide a very diverse range of different armed groups. As Ezequiel, I also wanted to bridge the gap in the legal scholarship of missing piece of non-state armed groups that have been often excluded from the legal analysis of finding regulatory solutions for internment and detention in non-international armed conflict. I was curious to select armed groups that vary in their organization and in their relationship between each other, but also as living entities within the society. I wanted to assess all the societal factors that impact their decision to detain and in general to either regulate or not deprivation of liberty. And these factors would include religion, they would include ideology, political stance, aspiration to statehood, anthropological and historical issues that are deeply rooted in the tribal and traditional values that some of these armed groups would have, while others not. And they would be very mushroom-like new armed groups that would be, popping up and disappearing fastly. And then that would have helped me to identify among the different contexts, including from the religious perspective, because some would include faith-based armed groups and others would be secular, to identify variations among them and how those variations relate to detention practices on the ground. And then overall, how would that relate to states? And state practice. So that was my main reason why I selected the 3 case studies. Obviously, the second reason is convenient one, and I also explained that quite extensively in the book. These 3 case studies were also my situations during my service at the International Criminal Court. So obviously, I knew all the actors very well, and it helped me in the data collection with all the risks of potential bias that obviously I did document, and I was honest about it. But because of that connection with my professional background, I was really able to collect quite exclusive and extensive research data. And I will not now skip your question. When it comes to engaging with parties to the conflict, obviously, and I also document this extensively in my book, I do give a magic recipe to everyone because I am a strong advocate of including research methods of social sciences in the legal scholarship and encouraging all the researchers to go in the field and collect field data that they can then incorporate in legal doctrinal research. And this is primarily because I do believe that law primarily serves to regulate social relationships and social issues. So if we don't know them and if we don't understand those issues from direct observation and understanding, then the law that we are proposing is not going to be very realistic. So I would say it's different if a researcher is engaging with state representatives and with representatives of armed groups to some extent. It would again depend on the level of organization of the group. the higher level of organization, the more similarity in the engagement with the state representative there is. But overall, what is really important is patience, use of intermediaries, and building trust. I would say trust is key, and transparency. I was full front with everyone who I am, what I used to do for a living, what I was doing at the time. I had a set of questions I was interested in, and I was very persistent and very respectful. I was just curious to talk to everyone. And I would say that all the parties felt that. And they were open to support scientific research. They understood the value of their engagement. And I didn't use social media, no. I know that we had a chat about it, but no Twitter, no Facebook, nothing like that.
So maybe let me just add why Yelena makes that joke. When I, many years ago, started my PhD and wanted to reach out to a certain group to speak to them, I tried that via Twitter. That was the reason at the time why I joined Twitter, and I failed massively. And that's also one of the reasons why I asked Jelena and Ezequiel how they managed. Ezequiel, anything to add, or shall we move on?
No, I mean, just a point on I mean, one small point is that, of course, the case studies are, in my book, are reflected on certain types of groups. And specifically, I develop a typology in order to actually develop this set of expectations on, similar types of groups will behave similarly. And the case studies are representative of that typology, which is de facto authorities, armed opposition movements or groups, and militias. But I want to point out that in addition to these case studies, also there is, I have reviewed certain documents produced by non-state armed groups with respect to detention. So non-state armed groups have included issues related to detention in their codes of conduct, in agreements concluded with other groups or states, in military decrees or orders. And that's also, documentary sources are also a very important source of information with regards to detention and the position of non-state armed groups in this field.
Thanks a lot for these insights. And with that, on the process of writing your book, I would now like to turn towards the substance of your book. And I thought about how to do it best. Your books are both really rich and of course books, so they're long. So I would maybe ask you whether each of you could present to our audience what you think are the 3 key takeaways from your book. So the 3 main issues that you thought came out of your research and that you think are most significant. And this time, let's start with Jelena.
Thanks. So 3 key takeaways of my book and my research would be, first, irrespective of being a state or a non-state armed group, security needs and interests are the same when one is a party to the armed conflict. This means that both states and armed groups detain for security reasons, for disciplinary reasons, and for reasons of serving criminal justice for some of the criminal acts. Now, this is very important for the discussion with which we started this talk, that there has been an extensive debate in legal scholarship on whether ALMA-IHL provides legal basis for detention or not. In practice, it's irrelevant because in any event, party to the conflict would detain. And I would say that even the legislators of Common Article 3 and Additional Protocol 2 admitted this necessity by referring to both terms, detention and internment. So that's the first key finding. Certainly, let's move to the second finding. The second finding, the very pessimistic one, bad news, is that I haven't identified that any of the parties to the conflict applied international humanitarian law as a relevant framework. Afghanistan did consider some of the language of Additional Protocol 2 in one instance of arranging some of the detention of persons detained by third states present in Afghanistan, but that was very quickly abandoned as an idea. And the only space that was out there was a sovereign space of domestic law to regulate detention of persons deprived of liberty for reasons related to the armed conflict. So instead of international humanitarian law, states apply their domestic legal framework for primarily criminal codes, criminal procedure codes, and armed groups apply their internal laws, their code of conduct, or other regulatory rules they have. Some would have less of those written codes, but more of verbal procedures of orders and relaying those and implementing those orders on the ground. And the third takeaway is that the deep polarization that exists in the treaty law of international humanitarian law between states and armed groups is equally present in the field when it comes to the detention. States detain members of armed groups and treat them as persons that violated domestic law and charge them under criminal procedure codes. Primarily, they're using counterterrorism framework, but not necessarily. They may also use regular criminal charges. While armed groups, on the other hand, perceive states as an equal in that aspiration to independence and sovereign rights. And they do also capture members of government forces, but they treat them similarly to prisoners of war, which means that they give them belligerent immunity. They do not prosecute them for participating in the hostilities. On the contrary, what I documented in practice is that some of the cases would easily qualify to some of the articles of the Third Geneva Convention.
Fascinating. And I do want to come back to some of the points that you mentioned. But over to you, Ezequiel.
I just want to add to this. So this is the depolarization when it comes to how states perceive armed groups as criminals that are jeopardizing sovereignty, and armed groups seeing states as a dream that they also want to live. But there is a similarity that I found, and this is the core essential finding of my research, and that is that both states and armed groups behave similarly when it comes to the detention of persons not taking direct part in the hostilities. And this is where the blurred line between unlawful and arbitrary and permissible is. And this is where possibly permissible detention can easily be justified arbitrary detention can be easily justified as permissible. So, and I would love to come back to that point, because I think what was very important when we started the chat, and thank you for that, is that you've really put it very clearly that there are certain IHL rules that are very clear and very obligatory, black and white, protecting detainees. And then there are others where there are gaps that can be easily used to manipulate the protection. Thanks.
Thanks. Ezequiel, over to you.
Thank you very much. No, it was great to hear Jelena, because now I don't have to repeat what she said, because I think we have similar findings. So the three points that I want to make is that the first one, I think the starting point of the discussions have often been on whether IHL provide a legal basis to intern in non-international armed conflicts. Well, I think one of the main findings is that I try to put forward is that we should focus first on the prohibition of arbitrary deprivation of liberty, that it is also included in the ICRC customary study as a customary rule. But the first point that I wanted to make is that this rule is only applicable for those detentions that have a nexus to the conflict. And for certain actors, certain non-state armed groups that are highly organized, I have found that, of course, there is an increasing literature on rebel governance in the legal sphere, but we observe that non-state armed groups or non-state actors with a high level of sophistication and territorial control, they also detain individuals for reasons that are not related to the conflict. So the question is whether the prohibition of arbitrary deprivation of liberty found in IHL can also be applicable to those situations. So my findings suggest that this should be responded negatively. So for those actors that have a high degree of organization and control, that detain both in the context of the armed conflict they are participating, but also for instance, common crimes, then the prohibition of arbitrary deprivation of liberty could be taken, at least for those detentions that are not related to the conflict, from human rights law. And again, this is clearly evidence for those non-state armed groups or non-state actors that are highly sophisticated and have a high degree of organization and control, as I put in the book, as de facto authorities. So there are different types of detention and different legal regimes that apply to those detentions. So the first finding is that one, is the importance of not only examining the whole detention activities from the lens of whether there is a legal authorization in international law, but also including the prohibition of the prohibition of arbitrary deprivation of liberty that exists both in international humanitarian law and in international human rights law. The second one, and this is where we agree with Jelena, is that in the case studies that I have worked on, the groups, they rely on their own laws, on their own sources as a legal basis to deprive individuals of their liberty. And they do that for cases of, that we can say, internment. They do that for criminal law detentions. They do that for disciplinary detentions. So some of these laws are quite sophisticated. Those other laws are non-written in nature. They are known by the community, but there is no written document sharing details on legal procedures and grounds, but still they are known by the community. Again, armed groups should be assessed through some sort of typology. We have so many different armed groups that the only way, we shouldn't put them all together in the same bag, because some of them have a high degree of organization, have ministries, have police forces, have judiciary systems. Others, they control one or two villages. They not provide services. They are mainly created to participate in a conflict. So again, it goes back to the issue of the application of human rights. So it's clearly evidence for those highly organized, but not so much for those that are have a lower degree of organization. So, but still, the different armed groups I've been in touch with, they rely on their own sources as a legal basis to deprive individuals of their liberty. And some of these sources, it's interesting because one may assume that, these sources, they are in competition with the territorial states' domestic legislations, but that's not always the case. There are non-state armed groups that adapt laws of the territorial states, non-state armed groups that create their own sets of regulations. Other groups, they simply apply the regulations that were in place before they took control of the territory. So this is quite important because, again, one may assume that the non-state armed group may not have the capacity to develop its own laws, but sometimes what they do is simply they actually follow those that were they were applicable before. So the second finding is related to the legal sources they rely on. And the third one that I think this is key is that based on this and some of these problems, that some groups, they don't have clearly written or legal basis, legal sources, legal grounds in a document, is that there is a need for humanitarian actors primarily or other entities to engage with non-state armed groups on detention issues. So there is a problem here because, of course, detention is seen as a public prerogative that is linked to the state powers. But still, as Yelena has correctly pointed out, and you have pointed out at the very beginning, we see non-state armed groups depriving individuals of the liberty in many non-international conflicts around the world for different reasons. So some of them, again, they have developed laws that are known by the community, are known by the people who might potentially be detained. Others, they might have not developed these laws, but still they deprive individuals of liberty. So how international law responds to this reality may affect the protection of individuals on the ground. And I do believe the third point is the need for humanitarian engagement on detention issues with non-state armed groups. Again, I know that the ICRC is the leading organization on this because of course, you're the leading humanitarian actor in conflict settings. But I think there is an increasing importance on detention issues as well, not just seeing detention as a public prerogative, as challenging perhaps the state-centric nature of international law, but it's a humanitarian necessity. Individuals are deprived of the liberty. They are in a vulnerable situation. Most often they're not there in mobile detention centers because of the nature of the conflict. They don't have access to lawyers. They don't know why they are detained. So this is why there is a need to engage with the detention authorities, in this case, non-state armed groups, to increase the protection and safeguards of those individuals.
Thanks, Ezequiel. And just maybe to elaborate on your last point, some of the latest data that I've seen coming from the ICRC is that it's estimated that there are over 150 armed groups that actually hold detainees, and that shows the importance and the significance of that issue. And there is humanitarian engagement with many of these groups, but probably not with all of them. And the ability to visit detainees and to work with armed groups to ensure respect for the applicable rules is highly dependent on the context. So there is certainly, there's always a need and probably also always room for more that can be done. I see time is advancing, and I don't want to keep the discussion only between the three of you. I do have more questions on certain aspects or certain points that you raised just now. For instance, the difference between states and non-state armed groups, how they detain, what that tells you about the law. Also different types of armed groups, Ezequiel, that you examine, what that tells us about the law. But I keep these questions, and I want to ask about one other thing that builds on, Ezequiel, what you said just now. If one looks at both of your concluding chapters, in each of these concluding chapters, we find a set of rules or principles that you put out as suggestions of what the law is or what the law should be. And I think, Ezequiel, you take a somewhat broader stance. And Yelena, in the sense, you look at from treatment to trial to internment at different aspects of detention, whereas Yelena, you look more specifically at the issues that you also examine in the book of internment and transfer. And so clearly, there is an urge on your side to suggest new rules. And so I wanted to ask, could you elaborate on why you think there is need for additional rules? And it might be easy to answer, but then more difficult, what form of rules do you have in mind? Yelena, I read in your book that it should be legally binding rules. So do you think about a new treaty? Do you think about model code of conduct or any other forms of soft law? I'd be curious to hear from both of you. I'm not sure who wants to go first. Is there a volunteer?
I can go if Yelena agrees. I think it's because I'm going to be brief anyways. So no, thank you very much for this question. I think the starting point of including 10 basic principles on detention by non-state armed groups is that I believe there is very little appetite in the international arena to develop a new treaty or some sort of new set of principles adopted by states on detention, but also on other issues. I mean, and this has been clearly stated by other people than me. And I think because there is this little appetite, the question is how we can better ensure that individuals are protected on the ground. And one way of ensuring this is not so much of suggesting new rules. That's not the goal of the principles, but is to clarify, or perhaps to summarize in a set of 10 principles, rules dealing with internment, rules dealing with criminal law detentions, rules dealing with access to detainees that are already out there. They're already in international humanitarian law. Some of them might be in light of international human rights law. And the goal of the rules, because of the variety of armed groups that I have seen the practice of, is to be representative of this different typology that I mentioned before. So this is why in various parts of the rules, there is a phrase saying like to the maximum feasible extent, and this is also reflective of what international humanitarian law says on different occasions. If we go to Article 5 of AP2, there is a clear reference to the capacities of non-state armed groups on detention issues and the different capacities that they may have. So I think based on that, I thought like perhaps the best avenue would be to have some sort of tool of engagement, I would say, that humanitarian actors could use, as kind of a basic document to rely on when talking to armed groups, but also of armed groups themselves, if they want to deal with one of these issues that they could understand. It's like, so if there is an issue of internment, they have to adopt a certain internal rule. If there's an issue of criminal law, there are different issues as well. So in a nutshell, the goal of this was not to suggest new rules, but based on the rules that are out there, to develop some sort of tool that can be used to engage with armed groups on detention issues.
Excellent. And sorry, I just want to make one comment on one point that you just made. You said it's important for armed groups to know the rules. It's important for humanitarians to have something in their hand to engage with armed groups. What is really striking is if one looks at how many armed groups are actually supported by other armed groups or by states, I think there's also an important aspect of states and groups that support others, especially states that support armed groups. They also have a responsibility to make sure that their supported actors comply with international humanitarian law. And for them, these rules can also be important that you mentioned.
Yeah, you make a great point. I'm sorry, just to comment on this 1 second is, I think you make a great point that armed groups should not be seen as actors in isolation. They interact with local communities, they interact with states, they interact with other groups, they interact with international organizations, they interact with religious leaders. And when we say engaging on humanitarian norms, it shouldn't be exclusively engaging with humanitarian norms with non-state armed groups. All those other stakeholders should also be aware of the obligations that exist in armed conflict.
Thanks, Ezequiel. Over to Yelena.
Thank you. I'm listening to two of you, and you're saying so many amazing stuff that I don't know from where first to start. But no, I fully agree with what Ezequiel is saying, that there needs to be a practical tool for practitioners in the field that are directly engaging with armed groups, and to help them to incorporate core procedural and judicial guarantees in their regulatory frameworks. But to start maybe with your question, why? In my proposal, I haven't invented any new rule. Primarily, I found what I actually did, I tested the existing rules, some of them or most of them that are applicable in international armed conflicts. And I wanted to see, would they stand the problem of capacity of armed groups that very much depends on their level of organization. And I will come back to that in a second, but just to say why we do need some instruments. First, the current legal framework when it comes to grounds and procedures and transfers is very weak. It is fragmented, it is confusing when it comes to its material and personal scope, and it lacks that implementation potency. What Ezequiel said, that armed groups are not very well aware of procedural rules that they should apply in their practices. I would say one of the strongest rules in IHL applicable to non-international armed conflicts are the rules on judicial guarantees, because they're listed in one place. They're there, and it's a package, and it's obligatory, and you have to do it. When it comes to procedural guarantees, this is not the case. Treaty law is silent, as much as it admits that armed groups will detain. It simply states when they were drafting additional 2 and common Article 3, they didn't want to give that sovereign right of depriving their citizens of liberty. That's an exclusive sovereign right. And that silence in practice transcribes into a mass amount of unlawful and arbitrary detention in non-international armed conflicts. So I would say that we do need, for 2 reasons, the set of rules. One is the security of local population. And second is the reconciliation process that starts often post-conflict. And detention practices and the scope of violations around it would somehow pave the way to the success of reconciliation process. What I experienced in the Balkans is the more extreme violations are in detention, the less possibility or the longer process of reconciliation there is. So even if you have clear rules on the treatment, if there are no safeguards around it, and in particular on that initial arrest of procedural guarantees, and I would be curious to research more on that interrelation between procedural guarantees and ill treatment, prevention of ill treatment. But it is very important for those 2 reasons to have at least those 2. I can think of many more why we need to have a set of rules. I did argue that they should be legally binding, and the reason for that is, although I agree that when it comes to making new rules and treaty laws is probably not realistic in the current state of international affairs. My starting point was international criminal law. As a prosecutor, I wanted to find sufficient legal space to construct war crime of unlawful confinement in non-international armed conflict, as it does exist for international armed conflict. And for that reason, I argue that core procedural guarantees should be equally obligatory for armed groups, because if they're not, then they can pick and choose what would amount then to. And the wording I use is unlawful confinement, again, for the reasons of criminal law. I do not use arbitrary detention because it is too vague construction for criminal law. Because, to prosecute someone for arbitrary detention, what would that mean? What would qualify as arbitrary detention, and what would be the tangible elements of crimes, which you would have for unlawful? But we can talk about that another time. So when it comes to the form, the form is irrelevant as long as we can find the quotation, some constellation that would work for armed groups. customary international law, to some extent, has been helpful. But as you both know, I do not consider that arbitrary detention is a customary rule of international humanitarian law, but human rights law. And it is still debatable whether it also obliges armed groups to comply with it. And then again, when it comes to the definition, it is quite difficult to explain to practitioners how would they implement that prohibition. So I do propose a set of realistic rules, and I do explain, in particular, when it comes to the requirement of the review, that some armed groups would not have sufficient capacity to comply with the requirement of judicial that comes from human rights law, and that the most realistic and the minimum standard is what already exists for internments in occupied territories in international armed conflict, and that's competent body. So that would give some flexibility in terms of the nature. That can be also administrative board as a body, but it needs to have the two qualities as a minimum, and that's independence and impartiality, or fairness in other words. And if an armed group is unable to meet those standards, I again argue in the book, they should refrain from detention and then either detain through ally armed groups or third states.
Well, thanks both of you. And Jelena, you said you don't agree with arbitrary detention being prohibited as a matter of customary IHL. Would you say unlawful confinement is prohibited as a matter of IHL?
No, I would also argue that. I argue that not, because that customary rule is based exclusively on state practice of applying international human rights law. So if the finding of customary nature would come from rules on humane treatment, I would agree with that. I would agree that the prohibition of arbitrary detention, as long as arbitrary detention amounts to one of the prohibited forms of ill treatment under IHL, is prohibited. But I need an IHL rule, either as a treaty law or as a finding in the international jurisprudence in order to find it as a customary in nature.
Thanks. And if someone else wants to come in on that point, you're most welcome. But we do have a question from the audience. Our colleague Brian is asking. He says that when we are thinking about armed groups, we normally think about IHL because IHL rules are designed to bind them by treaty law. And for instance, they set out judicial guarantees. But then judicial guarantees can also come from human rights law. And that's particularly relevant in his view, as Ezequiel also said, with regard to detention that's not linked to an armed conflict. And so he's asking, how do you address the interrelation between IHL and human rights law regarding detention? And how do you reconcile that with the idea that armed groups may have obligations when they're not specifically mentioned under human rights law as they are under IHL? Ezequiel, do you want to go first? Your take on IHL?
No, but I did go first before. Maybe Yelena.
We just heard Yelena. Okay, then Yelena.
No, I can go. Yeah, I mean, I think it's a very good question. I mean, the discussion about the relation between international human rights law and non-state armed groups has been out there for a number of years already, and different views have been proposed because, of course, as it is mentioned in the question, most of the sources of international human rights law, they address the behavior of states as state parties to the human rights law treaty. So if we take the ICCPR as state parties, if we take the Covenant on Social, Economic and Cultural Rights, the state parties, if we take, most of the human rights law sources refer to states and not to non-state armed groups with two exceptions. I mean, the two treaty law exceptions at least, the optional protocol on the rights of the child of 2000 and the Kampala Convention of 2009. There has been, however, an increasing practice of UN bodies dealing with non-state armed groups in the field of human rights law, and including in the field of detention by non-state armed groups. So I think this is one of the points that should be observed. I mean, it shouldn't be neglected. And yet, for me, the other point is these different types of detention that I mentioned before. I think because non-state armed groups deprive individuals of their liberty, and some of those detentions are not necessarily linked to the conflict, then bringing human rights law to the table could fill that situation, could fill that gap in terms of, again, the prohibition of arbitrary deprivation of liberty and what is needed on the part of armed group, on the side of the armed group. Having said that, I'm not saying it is not challenging, of course, from a treaty law perspective. But again, we see nowadays armed groups committing to respect to human rights law, although those commitments do not have perhaps a legal consequence at the international law. We still see those commitments, including on the prohibition of arbitrary deprivation of liberty. We also see human rights bodies calling non-state armed groups on detention issues and human rights law. We see human rights law, human rights institutions, human rights organizations dealing with non-state armed groups in the human rights field. So, of course, the legalistic and positivistic question as to the text of the treaties, it is challenging, but I think sources could be drawn from, again, the practice of human rights bodies dealing with this, and which I think it is needed specifically on the detention field.
Thanks, Ezequiel. Jelena, do you share that view, or do you actually have a different view on the subject of human rights and armed groups?
Mm-hmm. I agree with Ezequiel when it comes to the need that in armed conflicts of protracted duration, such as those that we have in Syria, in Yemen, that are lasting for years and years, where an armed group would take over governance functions of a part of the territory. Certainly there is the need to look into what obligations armed groups would have under international human rights law. But for me, this is the matter of policy and not the matter of law. Simply put, human rights law treaties identify states as subjects of those rules, most of them where they also address the armed groups, they're explicitly mentioned. And I would say that it is a question of law, and again, we are then, I'm going back to the courtroom, but for me this is very important because accountability part is a key element to compliance framework. Once a member of an armed group is in the courtroom, in order to prove unlawful conduct, there needs to be an obligation that this person had under the law as a subject of the law. And human rights law does not provide that obligation as a matter of law. But I agree, as a matter of policy, that is the case. And I agree that through some of the criminal acts that would amount to crimes against humanity, at least under the definition of incorporated in the Rome Statute, armed groups would have to comply also with some of the human rights law rules.
As a moderator, but also as someone who has followed many of these aspects, I would have additional views that will probably neither agree with Jelena or with Ezequiel, so we would have a third pole in that discussion. But instead of doing that, I would rather say we have a few minutes left. Is there anyone else from the audience who has a question? You can come in orally, you can come in through the chat, but also Yelena or Ezequiel, do you have points where you want to react to something that you've heard, or where you have a question to each other? I must say I do have one other question that's burning on my mind. But rather, let's see if from the audience there's a hand raised, or if one of you has a point that you would like to ask to the other. So nothing from the audience. I see you smiling. Shall I ask a question, or does one of you come in?
Oh, you go ahead.
Okay, I have one point which I find interesting. Ezequiel, when you spoke that in the principles that you set out, you put in question, or you put in caveats that you often find in IHL on capacity. And they of course make sense. You can only feed someone to the extent of your capacity. And then probably the bottom line is humane treatment. But on feeding and on certain family contact, here security consideration, capacity consideration can come in. I was wondering, and then we don't have the same with regards to judicial guarantees. And now when you think about internment, that both of you have been thinking about, where the law is non-existing or sufficiently less clear in NIAC, significantly less clear, and you were thinking about what rules should look like. How did you consider capacity of the actors? Jelena, you looked at states and non-state armed groups. Ezequiel, you looked at very different kinds of non-state armed groups as you described them. So what in procedures do you have, would you be open to caveats on capacity when it comes to who is unlawfully confined or who is arbitrarily detained?
That is a great question. Oh, sorry. Yes.
Please. Yeah, go first.
No, that is obviously a great question, because as you say, for some rules, it is accepted that there is going to be a different capacity according to the different level of organization of the groups. And this is inherent in the IHL when we deal with the differences between Additional Protocol 2 and Common Article 3, which is not seen in the customary ICRC study or in the customary rules that have been identified as customary in nature. I think it's much more challenging, and my view, of course, is that I share one of the points that Yelena mentioned, that for some of the issues, if armed groups do not have the capacity, it's better that they don't do it instead of they doing it in violation of international law. Fair trials is one of them, of course, although perhaps alternative mechanisms can be sought. But I do agree with Yelena in that point. Also because the armed groups, they do have a decision capacity. I mean, if they don't have the factual capacity to actually implement some of the rules, for instance, in terms of fair trial guarantees, they can, some groups in the past, they have transferred detainees to other groups that they did have the capacity. They have transferred detainees to international forces or to the territorial state for those individuals to be prosecuted. Then we have to discuss, whether those entities have the capacity to actually undertake those trials, because the detention was carried out by a group. But that's a different discussion. But what I'm saying is armed groups, they have acknowledged their lack of capacity to undertake certain practices. So I'm in principle in agreement with Yelena in that regard. But still, I think I go back to the point I mentioned before on the need to engage non-state armed groups on these issues. So I think, again, because detention has always been seen as this state prerogative, it has been quite, and administration of justice is the same, it has been quite challenging for actors to engage with non-state armed groups that are illegal nature under domestic law, because this engagement might be seen as legitimizing or as empowering those prerogatives. But the question is whether by assisting in those activities, in the end, if the goal is the humanitarian goal, is to enhance the protection of individuals in the hands of armed groups, that should be actually the focus, and not so much on the legitimizing the goals of the group. You're actually, humanitarian actors or entities are helping in the respect of international humanitarian law, not in the goals of the group. For some individuals or some institutions or some states, those might conflict, but they should be clearly separated. Yeah.
Well, Thanks, Ezequiel.
I think that's it. Yeah.
Go on.
No, I think the key is to also to assess the capacity of the groups to adopt internal rules on this, and not so much in terms of course, afterwards what they do with these rules, but at least, as when you engage with our groups, you need to have kind of a baseline of where, some basis to discussion, and that can be found in some rules or some basic principles, or it could be, of course, international humanitarian law. But again, perhaps having someone that having something that summarizes those rules might be easier for certain institutions or individuals.
Jelena, do you want to say something from your perspective on the question of the same rules for states and different types of armed groups?
Thanks. Well, I would say that certainly states already incorporate these rules that come from human rights law in their domestic legal framework. So all the procedural guarantees that we can conceive are in most of the criminal procedural codes, police laws, and etc. So for states, certainly from human rights law perspective, the obligations are there. And when it comes to the capacity, I would say it's not an issue. And in my book, I do reveal what I call double negation. So on one side, states negate international humanitarian law as a framework, but they also negate that their domestic law is inadequate for detaining persons for security reasons and maintaining that detention beyond a very short temporal scope of a few dozen hours under criminal law procedures. And so in this sense, states need to strengthen their legal framework in order not to violate their human rights law obligations in any event. And when it comes to armed groups, I already explained that I did the test when it comes to their capacity, and from all the examined armed groups that varied in organization from minimum organization under Common Article 3, mid-level of organization that would meet additional Protocol 2 requirement of controlling part of the territory, to the highest level of state-like organization, they all have the capacity to comply with most of the procedural guarantees, such as informing a person of the reasons of arrest, making a proper decision and assessing the reason that it's imperative in security to detain a person, providing notification and access rights, etc., and that the only stumbling block is the nature of the body that would review the process. So I would say that this is where there needs to be particular attention paid when it comes to regulation. How they are going to adopt those regulations, again, it's something that we all should work on from either our own perspectives or as a community. But there should be no shopping list of pick and choose. There needs to be core procedures that armed groups should comply with, and if not, then such detention would amount to unlawful. Again, I'm using unlawful because there is a difference between unlawful and arbitrary in essence of it. A detention can be lawful but arbitrary. So unlawful detention means that it wasn't in accordance with the procedures envisaged by the law and or on permissible grounds, also prescribed by the law. Arbitrary goes beyond that. And UN Working Group on Arbitrary Detention defined it as being also unnecessary, unproportionate measure, which again can be founded in law, but there is some certain subjectivity that it's embedded in that decision to detain. So I also think we need to work more on the terminology. of unlawful confinements, unlawful detention, and arbitrary detention and internments, simply because it would also make a difference for parties that deprive of liberty, but also humanitarian and legal actors, including prosecutors who are looking into the violations of IHL and human rights law on the ground. And if I may just end on the note that I haven't documented one single case, even before state courts, of prosecuting a member of armed group for arbitrary or unlawful deprivation of liberty.
Interesting.
Yeah.
Hey, we are unfortunately coming towards the end of our session. There's a question from Lena, which I pose it to two of you. Maybe Ezequiel, you follow that more closely. It's on Colombia. And Lena asks, in Colombia, the first restorative sanctions on illegal detention committed against civilians and military forces by the FARC will be imposed soon. What would be your views in terms of sanction for the commission of these acts of illegal detention? Does one of you feel comfortable commenting on that particular case?
I can jump in 1 minute, because one of the case studies in my book is on the FARC. So I think it's quite interesting what's happening in Colombia with respect to this specific issue, detention by the FARC, but also discussions that have happened in the past on detention by non-state armed groups in the context of the various conflicts that take place there. So there was a decision by the Special Jurisdiction for Peace last year. The case was specifically on detention by the FARC. I think there are 2 or 3 points that are worth mentioning. The first one is that but Lena, perhaps correct me if I'm wrong, but the amnesty laws in Colombia, they have actually, and the agreement between the FARC and the Colombian government, they have accepted that detention by the FARC in the context of the conflict should actually should be amnestied. So they will not be prosecuted. So the question is, what happens with those detentions that are not framed under this detention in the context of the conflict, and whether they're detention of the enemy forces or not. So this is where the case of the Special Jurisdiction for Peace addressed the various detentions of the FARC in Colombia, including detention of civilians in the territories they control, detention of enemy forces. I think there are different points. The first one is try to understand the practices of the FARC in this field. So why they were detaining, what was the legal source that they were relying on. Of course, there were cases of hostage taking, but there might be other cases as well that took place in the more than 50 years in which the FARC existed. They have adopted a couple of laws. So they have adopted, for instance, law number 2 and law number 3 that specifically dealt on detention. They are not very sophisticated, but they are laws anyways. And the last point that I wanted to mention is that in terms of the sanctions for the commission of these acts, the question again is to try to understand what acts are being actually prosecuted, which are the standards that are being prosecuted in Colombia, and for what reasons. But I thought it was interesting anyways that it was explicitly acknowledged that detentions by the FARC in the context of the conflict that were in line of international humanitarian law, I think that's the wording that it is used, should not be prosecuted but receive an amnesty.
Thank you very much. I both look at the clock, but I also listen to you. And I actually think, Ezequiel, what you said just now, that there is a legally significant, also from a criminal law perspective or from a transformative justice perspective, that there is a legally significant difference between different forms of detention and how it is done by non-state armed groups, but also by state actors, is an excellent takeaway. So if you agree, I would with that conclude the discussion on your 2 books. I think I can only reiterate what I said in the beginning. I highly recommend these books. In the chat, everyone finds vouchers with codes where you get a certain percentage off from the publishers. It's worth looking at both books. I've read both. and I think they are highly relevant, they are highly instructive for academics, for practitioners. So I warmly recommend them. And with that, probably hand over to Ido.
Thank you very much, Tilman, for great moderation of this event. And I want to thank again to Yelena and Ezequiel for your participation and great discussion. I have to say that that entire discussion made me rethink our entire project of book launch. I think it should be book launches of double book launch or moderated discussions. This is perfect. That was very interesting, and you actually set a new bar for our upcoming events, and that says a lot. So I want to thank again to Yelena. I want to thank to Ezequiel and Tilman for your participation. I want to thank to Natali Admon for her coordination of the forum, and I want to thank the participants who joined, and even some actually join right now. Unfortunately for them, I think. But not to say that, the event has been recorded and will be uploaded to our website and to our YouTube channel, which you're more than invited to subscribe to and check. Also, we invite you to check our social media accounts, mainly on Twitter and Facebook, to get information for upcoming events. Also, to enlist to our mailing list, and assuming that you're in the future and you're watching that on YouTube, I think the subscribe button is right here. So use it. And with that, we're going to conclude. And again, thank you very much for participating in our event, and have a good evening. Thank you very much.
Bye, everyone.
Thank you very much.
Bye, everyone. Thank you.